last speaker, I may as well sum up what some of the other speakers were also saying earlier today. Ultimately, the taste of the pudding is in the tasting. The proof of the pudding is in the tasting. So it's all about implementation, ultimately. And the NCLT, as it is constituted, will go a long way towards implementing most of the provisions of the Act, and also to streamline the legislation as it stands. So currently, we have a slightly moth-eaten administration of justice under the Companies Act. We have the Company Law Board, which is entrusted primarily with 397, 398 Operation Mismanagement Regime, and also other smaller sections. We have the High Court, which is entrusted with winding up of companies. And we also have civil courts to some extent, to the extent that Foss and Harbottle and such cases still have relevance in terms of class actions. And then we have the BIFR, as well as the AAIFR. So these tribunals have been set up for Sikh industrial companies under the Sikh Industrial Companies Act. So the new Companies Act aims to streamline all of these tribunals and also take away powers from the courts to the extent that they have been administering those powers, and to also permit for a single tribunal with benches across the country. So enabling of specialized tribunals has always been slightly contentious. It has been contentious for the last 20, 25 years, because there's a principle that the High Court and the Supreme Court are constitutional bodies, and natural justice ultimately has to reside with them and the court subordinate to them. Having statutory tribunals has always been opposed on this basis, saying that natural justice may not be sufficiently served, independence of the judiciary may not be sufficiently served, because ultimately tribunals and the members are appointed and created by the government. So the same problem arose when the NCLT was first proposed in the Companies Act 2002, after the Justice Iradi Commission had proposed the creation of one NCLT. The proposal seemed very sound. However, there was a writ petition filed before the Madras High Court, and in that petition, the creation of this tribunal was challenged. The heartening aspect of this case was that the Madras High Court said that Parliament does have power to create such a tribunal. So it is not beyond the legislative competence of Parliament to create NCLT. However, there was a lot of concern expressed by the High Court with regard to the eligibility of the members, the composition of the members, and also with regard to what the tenure was. So ultimately, there were cross appeals filed, and since 2002, the matter was in court till 2010. And finally, a 5-judge bench of the Supreme Court finally decided that yes, Parliament can create tribunals for administration of justice, but they did give detailed observations and detailed guidance to Parliament and to the Union of India with regard to how these members and how these tribunals are to be constituted, and what are the safeguards needed to ensure that the tribunal does not, somehow fall down on the principles of natural justice. So the Supreme Court gave something like I wouldn't say a green light, they gave an amber light. The heartening aspect was that the Union of India was okay with most of the suggestions and decided to implement them, so that there was a constitutional validity. And then in 2013, the new Companies Act has brought in this creature, the National Company Law Tribunal. So currently, as you have the CLB, you have the BIFR and AIFR, which deal with Sikh industrial companies, and you have the High Courts. High Courts are dealing with restructuring, they're dealing with amalgamations, they're dealing with appeals from CLB, and they're also dealing with winding up matters. Now, one of the interesting aspects about the High Court's powers generally is that in a lot of places, such as in 391 schemes, Section 100 schemes, as well as to some extent in winding up matters, the High Court has in any case stepped back somewhat. So in 391, for example, there is an established jurisprudence that the High Court is an umpire, and you have to ensure that the scheme is in accordance with law. However, the High Court is not going to step in. You have to take your consent from your creditors, you have to take your consent from your shareholders, and also get a notice out to the RD. So you could already see that one of the most dispute-related subjects, which is 397, 398, had already for decades been lying with the CLB. So in a sense, the whole argument about the NCLT, whether it's valid or invalid, was something which really delayed this creature for more than a decade. In my view, the NCLT is an idea whose time had come a long while ago, and the biggest advantage that it gives you is that it creates certain judicial strengths which are not there currently with the CLB. For example, the NCLT has the power, just like a high court, to find you in contempt if you don't follow the orders of the NCLT. Similarly, what you found in the CLB is that while it was preferred that you should have the chairperson as a retired high court judge, there was no requirement as such. It was not mandatory. And secondly, there was no requirement for the chairperson to be a high court judge for any duration of time. So it could have been a person who was a high court judge for, say, 2 years and then suddenly was appointed as a CLB chairman. Now, the NCLT, the law provides that the president has to be a high court judge for at least 5 years before being appointed an NCLT chairperson. And also on benches, we had this really complicated problem with the BIFR, in that the BIFR only has all its benches. It has several benches, but all of the benches are in New Delhi. And so the BIFR and its appellate forum are both based in one city, and this is a very large country, and this used to be a big logistical problem for Sikh companies across the country. And the geography of the CLB, while slightly wider, is not as wide as the High Court, in fairness. The High Courts, of course, every state has either a High Court or a bench of a High Court, whereas the CLB has regional benches. However, the NCLT will most likely be following a pattern closer to the CLB pattern, which is having regional benches, although they're yet to be notified. We still have to know how many benches there will be. It is hoped that there might be more than simply 4 benches. There might be 5, 6, because another aspect of the Company Law Board is that it had benches in cities which at that time were considered to be cities which were, the 4 major cities, the Char Mahanagar that we used to have. But now, 20, 25 years later, we have more cities coming up in India, and it would be useful if they have a greater geographical spread in terms of the benches. On the other hand, you do have this interesting aspect of tenure, which was another thing that the Supreme Court had pointed out, that you cannot have a very short tenure for members and for chairpersons. So there is a fixed tenure of 5 years which is prescribed under the new act, which is very useful because the idea is that if you're going to become an expert in the field of deciding these disputes, then you should have some time in order to do it. At the same time, it should not be that, and it is hoped that the problem we faced with CLB in the past was sometimes you had one person dominating. This is also something which may not happen because now they are providing for a structure which is quite similar to a high court in the sense that you have a single member deciding most cases, but the president can decide that a case has to be decided by 2 members. So similar to a division bench in a high court. And at the same time, if those 2 members do not agree, then they can give the reasons for the disagreement and the president can weigh in and decide it. So in that sense, the judicial nature of this tribunal is strengthened because this has always been the concern amongst lawyers as well as some litigants that in the interest of speed, justice should not suffer, right? And there's always been a concern that, justice delayed is justice denied. But ultimately, whenever the administration of justice is outsourced to a tribunal, which is not part of the court system, the concern is that if you have people who are subject to pressure from the government, if you have people who are not appointed in a manner which is transparent enough, you will always have a concern that they may not be able to hold up to that pressure when it is applied on them. And of course, as I mentioned, in the case of company law administration, we already have a very varied jurisdiction. So in a sense, the high courts had already stepped back from a lot of the justice-related aspects of the administration. And you also have, in winding up, you also have this strange aspect that now winding up with the official liquidator system was not really working, right? We all know that insolvency generally was not really working. You had 2 components to it. One was bankruptcy, which was handled by BIFR, and the other component was your winding up, both a voluntary winding up as well as involuntary winding up, which is handled by the high courts. This was not working. The files were permanently with the official liquidator. You had a lot of abuse of the process through various unions, various interested parties approaching the courts and weighing in and putting pressure. And one of the tragic problems of having high courts decide winding up matters is that the company judge himself is not going to be there in that courtroom for the entire duration of the matter, nor will he be in the courtroom for even more than maybe 3 or 4 dates in that matter. So one of the good things about having a dedicated tribunal is that you have members who are handling these matters day in, day out. So in fact, the Act also allows for the tribunal to have specialized benches to deal with certain aspects of the Act. So for example, to deal with sick companies, you will have a specialized bench, which will only be dealing, so they will not be dealing with operation-based management on a day-to-day basis. So this kind of specialization and departure from the company judge concept, which is currently prevalent, is very useful. So effectively, it is as if you have a court which has special benches dealing with different components of company law, rather than having one bench which deals with everything under the sun which is related to company law. And then you have, of course, the mandatory mix which is there in tribunals between judicial members and technical members. So technical members, also the Supreme Court insisted, have to be people who are not just members of the Indian Company Law Service. That was the original proposal in 2002. The idea is that they should not be people who were just doing clerical work. They have to be people who actually handled disputes, who actually had senior roles in company law administration in the country. So all the guidance given by the Supreme Court was absorbed by the government, and they, in their legislation, they have put in a mix both in terms of experience as well as expertise in order to adjudicate the disputes. The